Hi everybody, welcome back to the 10th of an hour with Griffin Bridgers. For today's episode, episode 55, we're going to talk about a spousal IRA rollover from a trust that's structured as a survivor's trust. We're going to look at a recent private letter ruling that blesses this method and some of the powers that went into the trust and where you might use or deploy this type of trust or strategy. Now, as always, this presentation is not intended to substitute for legal or tax advice. Now, this isn't a presentation that's designed to, dive into spousal rollovers in depth, but I think it's important to note that this is an option where a decedent owns an IRA and dies and names a spouse as beneficiary, then generally that spouse could roll over their IRA into a spousal IRA. Otherwise, in most cases, a beneficiary of an IRA has to have an inherited IRA, and there's no real rollover option with that. And the big difference between the inherited IRA and the spousal rollover IRA is that required minimum distributions have to start in the first year after the death of the IRA owner in the case of an inherited IRA, except where the 5 or 10-year rule applies under the Secure Act, and that's a subject for another time. But with a spousal IRA, the spouse can at least defer distributions until their required beginning date, which is April 1 of the year following the year in which the spouse reaches age 72. However, there is a minimum age at which you can take distributions penalty-free. In the case of the spousal IRA, the spouse has to wait until age 59 and a half to take IRA distributions. Otherwise, any distributions could be subject to a 10% penalty tax, whereas with the inherited IRA, there's no such penalty tax. Any distributions from an inherited IRA can be made at any age without penalty. Now, is there a way you can integrate trust planning into this and still preserve the ability to have a spousal rollover IRA? And the answer is yes. We've talked about in the past how the IRS, in some cases where the spouse has enough powers over the estate or the trust, if the estate or trust is a beneficiary, then the IRS will treat the spouse as effectively being the beneficiary of the IRA. Now, typically, you have to have a situation where maybe the spouse is the sole beneficiary and maybe has the right to all income and might be the trustee or personal representative. And that was the case here in Private Letter Ruling 2020-40003. But there's a twist here. The spouse was given the power to revoke the beneficiary trust in addition to being the sole trustee and income beneficiary. Now, for those of you not nuanced in estate planning and in private letter rulings, really they give minimum facts just to reach the tax conclusion, and you have to put 2 and 2 together. So nowhere in this ruling did it say that this was a survivor's trust, but this type of structure does in effect create a survivor's trust, which is generally not necessarily, might not be the case here, but it's generally the name given to a share of a joint revocable trust given to the survivor. Now, the caveat to that and the twist to that is that usually the survivor's trust would hold the survivor's share of community property within a joint trust plus the survivor's separate property in that joint trust. And because of that, because it's usually the survivor's own property, that trust would be revocable, whereas the other parts of the joint trust that holds the deceased settlor's community property and separate property would become irrevocable at the deceased settlor's death. So you use joint trusts a lot in community property states. I don't know if that was the case in this ruling, but context clues showed that it was probably the case. But where the IRA is community property, you'll generally have a situation where the spouse is at least a beneficiary of one half anyway, so it makes sense to make the spouse the beneficiary of the whole. And in that case, Instead of using, for example, a marital trust as the trust beneficiary, it might make sense to send the entire IRA to the survivor's trust, which would allow for a spousal rollover. Now, that's a situation which could prevent RMDs from having to kick in immediately, which is more important now that the Secure Act has limited trustee beneficiaries in the case of IRA stretch distribution planning. So there's better deferral, and there could also be better creditor protection with a spousal rollover IRA in general when compared to an inherited IRA. So some key takeaways here is when you have a community property IRA, it may be helpful, instead of naming the spouse or marital trust, to name a survivor's trust as the beneficiary of that IRA. Doing so could allow for a spousal rollover. There might be some contingent creditor protection benefits that could be gained from the back end above and beyond the benefits that are just attributable to a spousal rollover IRA as opposed to an inherited IRA. But you have to keep in mind that the drawback here is that the spouse now has to wait until age 59 and a half to start taking distributions without penalty. Now, most IRAs payable to beneficiaries, including trusts, will become inherited IRAs, which do have lower creditor protection generally under state bankruptcy law. Or federal bankruptcy law, and some state laws, I should say, when compared to a spousal rollover IRA. So there's lots of different permutations to this, but this may actually be a helpful creditor protection tool that not many practitioners have thought of. Now, as always, if you have questions or topic suggestions, you can email those to me at griffin.bridgers@gmail.com. Thank you for listening to this episode of The 10th of an Hour, and I look forward to seeing you in the next one.